Thank you. Good morning and welcome to the Legal and Justice Subcommittee, in which Arlene Feld and myself are co-chairs. It is February 14th, 2023 at 11:30 a.m. Happy Valentine's to everybody. I will start with the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to our elders past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. Let's see here. Give me a second. Do we have Angela here yet? Oh, there we go. Thank you. Just looking. All right. So the first item on our agenda is family court. So I believe one of our goals is to think outside of the box and to get creative. I was never good at art, but thank goodness there's other ways to get creative. As we're no longer looking at incarcerating people for punishment, we are now looking at how to assist people who have committed crimes in rehabilitation with the community and their families, sometimes determined as necessary, as well as a timeout for individuals. However, creativity is something we are lucky to have in our community. I would like to introduce Whatcom County District Court Judge Angela Anderson. Prior to becoming District Court Judge, she was the Chief Deputy Defense Attorney for Whatcom County, and she was in private practice and represented defendants for the City of London under contract. I would also like to introduce our probation manager, Jake Webush. Jake has over 20 years of experience in Whatcom County and was a juvenile detention officer prior to probation. So as you can imagine, both of them have had lots of experience with families, incarceration, and ways to try to solve some of the issues. Angela and Jake are here to explain to us the Whatcom County Family Court practices and benefits it will provide to our community. Take it away.
Wow, thanks. I liked all the creative.
Jeez.
Yeah. Also, you forgot my most important former title, which was Incarceration Reduction Task Force member. So, oh man, former retired. But it's great to be back. I can't take much credit for what we call Family Justice Court. It's really the brainchild of Mr. Webush here. So I'll let Jake sort of give you guys the sort of background.
The nuts and bolts.
Yeah.
I'll give the nuts and bolts and turn it back to her. So yeah, we, as you know, I think I've talked about some of the programs that we are offering here at probation in the past few months. So I'll kind of skip over those, but just to kind of focus today on family justice calendar. And so what we were seeing is we're monitoring the funds for that DV POTS program, so the funding for treatment. And we weren't seeing the greatest results of what we were hoping for, people following through that were receiving that funding, like people I'm referring to, clients, defendants. And so we're thinking, how else can we increase accountability and get some better results on top of just providing financial support for their treatment? So the three of us kind of came together, three of us being Bruce as well, who's present here, and came up with the idea of Family Justice Court. And so what it is basically those that are receiving the funds, and now on top of those folks, we're also putting in place the felony drop down. So many of those coming through Superior Court, from Superior Court. So they can be receiving the funds as well through DV POTS, or just attending treatment if they have financial means, or as well part of the program here, the DV MRT program that we offer on a couple times a week here. So I've spoke about that before, so I won't get into too much detail. So those are the kind of the folks that we get and are focused on for this family justice calendar. We currently have, I think I have a spreadsheet here next to me with 18 individuals that are in the program. We're still in the first year of that, so we haven't really put together stats of substance yet, but we are obviously going to be doing that and monitoring that. As far as the nuts and bolts, it's every 3 weeks on a Friday calendar at 10 o'clock. And they start off coming in on a week on every 3 week basis until they show us compliance. And then once they show compliance and they're making headway, we could start spacing these out. Some of them aren't coming tell every 2 or 3 months or so, I guess, that are doing well, and they just kind of check in and see how things are going. So as far as what kind of goes on at the hearing, I'll let Judge Anderson kind of talk about that.
Sure. Part of what we're trying to do here is to make the check-in with the court not so onerous and inconvenient, and also to empower the participants a little bit more. So they're allowed to zoom in. The goal is to keep them in court. I mean, our court's running maybe 15 minutes total. It's really quick. It's fast check-ins. I explained it to the participants, hey, I'm putting you in this program because I want to see how well you do, but also I want to hold my programs accountable. And so I want you to have a dialogue with me if something's not working, you don't like something, you know, we're paying a lot of money for these programs. Are they doing what they're supposed to be doing? And we've made it a lot less formal. It's a first name basis court. There's not a prosecutor present. I have an agreement with the prosecutor's office. If they violate, you know, new charges, something pretty significant, I'm going to kick it to a contested hearing where a prosecutor is present. The goal of this is just checking in with them. Are you making progress? Are you doing well? And I think we're getting a lot of feedback from them that it is working. It's really nice. If you're in compliance, you get to go first. You get praise. People who maybe aren't get some reminders, but they get to see those who are in compliance got to go first and to leave. And a lot of the guys who have, I say guys, we've had women in it too, but a lot of the people who have sort of graduated out of the program have said really good things and how their families are doing well and they're employed. And so I do see a bit of a trickle down effect on the newer participants. But again, it's a really informal court hearing to just sort of check in and encourage them and get feedback.
And on top of that, each individual is also on supervision. So it's kind of, they're checking in with us on an ongoing basis, depending on their risk level. The frequency of that is determined. But then seeing Judge Anderson on a frequent basis always kind of triggers that need for further compliance. So I think we have a question.
Yeah.
Oh, I think you're muted there, Arlene.
Yeah, Arlene.
Here we are.
What do you, when you say progress, what are you specifically looking at that tells you there's progress? And the second question is, what are typical charges?
Great question. So to make it again into our program, it's usually they're receiving DV POTS funding or doing our DV MRT program. But I'll also put in some of the high risk, high needs defendants I see. If, for example, their probable cause statement was a little frightening or a lot frightening, or if I have an agreement from the prosecutor and the defense attorney to put them in this program. The charges I typically see are assault in the 4th degree domestic violence. That's probably the number one. Maybe violating a no contact order, and maybe some sort of property damage, domestic violence. Those are my typical ones. And then progress to me means they've gotten either their domestic violence evaluation and started attending those classes, or they're attending DV MRT. Correct me if I'm wrong, a lot of our individuals are dual diagnosis. There's something else involved, mental health or substance abuse. And also what's kind of nice about this program, Arlene, is my more frequent touches with the participants, we're able to communicate about maybe what's more important, right? And get to balance that and say, oh, right now you're really having a substance use disorder. It's making it hard to comply with everything else. Let's focus on that. Or your mental health is really, your mental health is going great right now. You're in full compliance. Maybe we put a hold on that evaluation while you focus on your DV MRT for a while. We can do a lot more than we normally can if I just throw them on probation and then Mr. Weebush has to make those calls.
And we're looking at their treatment reports. We get monthly reports. We're looking at those. We're looking at the comments. Is there, are they making headway? Are they getting it? Are they applying it? Also with our MRT, I facilitate one of the groups and we have staff that here that also select the other ones. And so we're taking a look, where are they at? Are they progressing? Can we report, what step they're on? What they're still struggling with might be something we're looking at. So it's kind of just real time checking in.
The cool thing is, Arlene, we're covering the cost of the DV programming for most of these individuals. And so that barrier, also known as an excuse to get started, is eliminated.
Yeah.
So we can dive right into the programming, where sometimes on the regular probation calendar, it takes a long time to even get started in the program. So these guys are getting right into it. And gals.
Thank you so much.
Two things. One, I wanted to briefly mention thank you to Maya Vanyo and Eric Ritchie for bringing this program to light. And they also mentioned some individuals that were charged with felonies that may be dropped down to your program for success. That might not be an option for them in the felony court. Is any comments or thoughts on that and how that's working?
I mean, they're coming through on Friday mornings, so they're resolving and coming to us. So, and then we're putting them on the calendar. So I think, it's pretty early on to know results on those. We're getting them as fast as we can to be engaged in the programs that they qualify for. And, I think we'll keep taking a look at it as time goes to see how effective it's being for them.
It would be really wonderful if the two of you would find a way to capture the experiences of families involved here and there and write it down, because one of the things that we're trying to do is to let our community know what has been done and what is being done and the effects of it. So those are the people who can tell us what effect those programs have on them and on their families. So this would be really useful.
That's a really great point.
Yeah.
Are there any struggles you're having with the program at all, or needs that the task force can assist on?
I didn't really think of any. I mean, we're adjusting as we go. I don't know, necessarily struggles. I mean, finding mental health treatment's always a, a battle, but we're working the best we can there.
Thank you. Stephen?
Thank you both for the report. Jake, I do remember that you talked about DV plots with us before, but I apologize that I don't remember the details
Sure.
of that program. Could you talk a little bit about that? Is it just a curriculum like the MRT thing?
Right. No, it's funds. So it's domestic violence perpetrator opportunity for treatment services, as Bruce put the name to it there. And it's county funds, and there's also funds for the city of Bellingham that are designated for this. And we monitor, it's 20,000 currently for district or for Whatcom County for these clients for reimbursement of services. So it covers the expense so long as they qualify for indigency. They'll get a cost of an assessment and for whatever treatment is recommended. And we have a contract currently with Phoenix Counseling, and it's open to other agencies as well if they wish to come into contract with the county, but currently we just have the one. So they attend services there, and then we reimburse their expenses for services.
So I know that kind of treatment is often an up and down thing, and you go by treatment reports, I guess. How do you judge, besides just participation and showing up, that they're actually doing satisfactory?
Well, we asked if they write comments on their progress. Are they refusing? Are they understanding their role? Are they still blaming others? So there's notes that we put on there, and then it's either myself typically or Peggy Souza, who are very, we've had a lot of years working with domestic violent offenders, and so we, as we meet with them and as we talk about, the progress they're making, we can kind of pick up on, where things are at, as well as when they report to court. And see Judge Anderson and the comments that are made and the aha moments that they have, you can kind of pick up on those. So
I I mean, I could be totally wrong, but I feel like a lot of our participants have been pretty candid with me on the bench. You know, we had a period of time where the DV services, we had one agency closing down, Phoenix coming up, and we were having really large class sizes of 20, 28 people. I couldn't even imagine discussing, you know, domestic violence in that type of situation. And they were candid with me about, I'm not having a good time in my class. I'm not feeling like I'm getting anything out of it. I'm frustrated. And we tried to work with them. Some of them got switched over to the DV MRT.
Mhm.
And also just acknowledging, yeah, this really stinks right now. We hear you. Hang in there. It's going to get better as soon as more classes are opening up. And that seems to have cleared up a little
It
bit.
has a lot, yes.
But I think it's kind of refreshing for these individuals to get to say to the judge, this really stinks right now. Or I'm unhappy. I want to comply, but I'm having a tough time doing it. There's something cathartic about that, and having the judge go, okay, you know, I hear you. I'll give you another month or two, and not, I don't know, like I said, I want to hear that the programs are working and vice versa. So having a say in your treatment, you always tend to do a little better.
Thank
I'll
you.
throw in one other question. Are we set up to track data on outcomes like a year out or something? I mean, I would think that would be part of the point of this, is you don't want to see new charges coming
Right.
up within the next year or two.
Yeah, I mean, I'm looking at it on my other screen here. We have a spreadsheet with our folks, and we'll be monitoring that. As you know, like I said, it's still early on, but we'll be keeping an eye on that, and certainly something we can bring back at a later time.
And Stephen, we're really trying hard to take high risk, high needs individuals in this
Yeah.
program with like the felony drop down. So our stats are going to be honest.
Yeah.
No, that's great. I appreciate the prosecutor's office going along with that.
Many of these folks are ones that have not succeeded in the past and have had multiple attempts at treatment. And so we're doing what we can to give those folks a try, take away that barrier of expenses, whether it's through the DV POTS program or through the services we're offering here through the MRT program. So
See, I wish I could name names, because Maya and Eric would recognize some of these names, but there's like 3 or 4 who are just, you go, what? They've been doing this well for this long. And for some reason it's working for them. I think Jake's right. That's that quick check-in with the court. It's holding them accountable more frequently. And it seems to be really working for a couple of these guys. And again, I'm saying guys, because I think we're mostly gentlemen. I'm sorry.
Yeah.
I have a question for you. Have there been any cultural, language, or ethnicity barriers?
Well, Phoenix Counseling actually has the Spanish speaking services. So I think we have one pending right now for DV POTS that just came through that we'll be referring over there. So it shouldn't be, there shouldn't be a barrier for that at all. If the services are needed, we could certainly have them be a part of this program as well.
So I guess my only other question is to kind of play off of Stephen's, is making sure that we have accurate data in the future, is if there is any language or cultural issues that come up, that we make sure that we're tracking that as well. And then providing some of that information to the index committee, maybe on an biannual basis. So we can just check in to see how things are going. And if you don't have enough information biannually, then we'll go on to an annual basis. But just to see how this is going, and if it's something that would be beneficial for gathering funds from the state or BJA for more mental health courts, family courts, veterans courts. There's a lot of funding out there that might be beneficial for our county in the future moving forward. Is there any other questions or anybody else would like to add to this conversation? Thank you so much. Really
Yeah, thanks,
appreciate you
guys.
joining us and giving us information on this fabulous program. Thanks again.
Thank you. Bye, guys. Good to see everyone again.
So our next on the agenda is jail release and coordination with behavioral health services. And we are blessed to have Caleb Erickson, Lieutenant, and Bureau Chief Wendy Jones, who have been with Whatcom County for numerous years, and we're happy to have you here to discuss some of the coordination and behavioral health. I know it doesn't always go as fast as we'd like to, but hopefully we're making some progress. Take it away.
There were kind of 3 quick points I wanted to make, and then Caleb can figure out what I forgot. And he can make sure that gets addressed. One of the challenges that we've been dealing with has been a limited number of reentry specialists. We've had one, and then we didn't have any for a while, and now we've got one again, and she does the work of about 4 people, so that's cool. But their health department put in for supplemental budget request to hire 2 additional reentry specialists. And that was Perry, you nod your head or shake it, but I think they approved it, right? So that's going to be helpful. It'll give us 3 people, which means a lot more people can get touched on more rapidly. So that's the really good news. And there are little periods of time where communication seems to be working pretty well between the jail as a whole and the rest of the system. And there are other times not so much. A really good example of when it did work was I got a phone call at 5 o'clock on a Thursday afternoon from one of the public defenders. And she said, listen, I've got this client, and she ran down what all was happening. We're taking him for a special set on Monday. He's going to plead out. We've got a place for him to go down in Snohomish County. Transport's all arranged, but he needs 30 days of medication, but otherwise they won't take him. And she said, I don't know how to do that. And I said, well, you just did it. That's fine. I'll get a hold of nursing. And so I did that the next morning, which was a Friday. The meds came in on Saturday, and they were waiting for him after he got back from court, and he was released to go to a treatment facility, basically. The interesting thing about this individual was he was in custody for 129 days. He was sentenced to 7 on the day that he pled out. So that meant he spent over 120 days in jail waiting for the case to get resolved. And that kind of leads to the last point, is that a lot of our offenders get what's called credit for time served release. They will sit in jail for long periods of time. And part of it is a lot of these cases are complicated. It takes a while for the attorneys to try and work out a mutually acceptable plea. Sometimes the client doesn't necessarily want to agree with that. But I went and I pulled releases that happened after Superior Court calendar on Thursday. We had one individual who served 17 days. The plea agreement was reached, and he was actually sentenced to 5 days, and then he had to pay some fines. I had another individual who was in jail for 201 days. He was PR'd. Now he did have 125 of those days was done at Western State Hospital, but he was PR'd and released to the community. So the case isn't resolved yet, but he's no longer in custody. Another gentleman was in jail for 62 days. He was sentenced to 45 days. But again, this is, they will go in at a calendar on Thursday mornings, and the plea gets accepted by the judge and everything's fine, but then they're out of jail within an hour, which means because we didn't know that they were going to be resolving this case, except for something showing up on calendar. The reentry specialists don't know. They can't work with the client. They can't work with the court system or try to get a place for them to go or how to get there and that type of things. And some of them are, we had one gentleman who was in custody who served 559 days. He wound up being sentenced to a total of 364. So he was in jail for well over a year. And that's not unusual. And it's just, I think, a symptom of an overloaded court system. And sometimes not great communication that doesn't happen. But one of the things, the systems issue I'd like to see if maybe this committee or the system as a whole can tweak is if the defense attorneys primarily, but I've heard from prosecutors telling me, giving me a heads up on on that somebody is going to get their case resolved. If we can know, even if it's 24 hours ahead of time, reentry may be able to make sure that if they need medications, we get that taken care of, if they've got a place to go. If it's somebody who came in the middle of summer and they were wearing flip-flops and a pair of shorts, and it's now the middle of December and it's freezing outside, that we figure out how to get them closed so they don't freeze when they leave. There's a lot of the practical things that happen that makes it very difficult when transport brings somebody back from calendar and saying, he's credit for time served, we think, can you take a look? But it looks like he's done his time. And so if we can figure out a way, and this committee might be a really good way of doing that, figuring out a way of getting a heads up, even if it's just a couple of days. Even better might be when the note to the court goes up to note the issue up for guilty plea and sentencing, and that it's really going to happen. Because that's the other thing, is that we'll kind of get prepared and then it gets continued the morning of calendar. And we're dealing with human beings and systems, and I get all of that. But that's one of the issues we have. We get people who get stuck for long periods of time, and that's for a whole myriad of reasons. But when the time comes that they get released, if there is not some sort of a safety net out there, the chances of them coming back are really high. So any advance warning we can get, whether that comes to one of the correction staff, whether it goes to what will be a 3-person reentry team, which would be great. Otherwise, even just letting medical or MHPs know, because they can make that information gets out, we can do some problem solving. And our tradition has been that if we have, we had a gentleman who was being released from custody. A case manager he had in Skagit County had arranged for him to get a bus ticket to go home, which happened to be Chicago, but they had no way to get him down there. So I had the transport guys come in early. They ran him down to Skagit County. The case manager met them, got him on the bus. 2 days later, he called the case manager and said, I'm home. I'm so glad. Thank you very much. So we can utilize transport resources and a wide variety of other things. But if we don't know, we can't do it. And oftentimes we can't do it on half an hour's notice. So that's kind of the things that I wanted to touch base with. Caleb, have I forgotten anything?
I don't think so, Chief. I think it's a pretty complicated system. There are lots of potential pitfalls and issues, but the largest frustration or challenge that we're facing today is that the vast majority of the people who are in custody are not sentenced until they are, and then they either go to prison or they get released. And so it's that distance in time or that short window of time where reentry might be effective is a real challenge.
So I guess at that point, we throw it up to any questions that people might have. Hi, Arlene.
Sorry.
It's kind of hard for me to be calm about saying this because what you're telling us is so appalling. And we're talking about it like, this is just breathing, but do these people have any redress for the injustice of being in jail so long when they're not even going to be sentenced that number? I mean, don't they have any way?
Well, Arlene, oftentimes, and I don't know, Maya might be able to speak closer to this. She's defense attorney. I'm sorry, I got her mid-bite. But one of the issues can be is not only do the prosecutor and public defender have to come to something that's mutually acceptable, the defendant or my customer in the jail has to understand what that is and agree with it. And sometimes it takes multiple attempts on the part of the public defenders or the defense attorney to be able to make sure that their client understands, make sure that they're going to be able to follow whatever conditions the court sets down and that type of thing. It's not, a lot of our population, it takes a long time and repeated effort in order to get them to understand what their attorney is trying to do for them. And occasionally you kind of heard it touch base with Judge Anderson and Jake, is that sometimes an understanding of what's going on is something that's unique to each defendant. And so it takes a while before they're willing to see the logic behind it.
Do you think that this would be one of the places in our justice system where the use of navigators to facilitate this process might be helpful?
Well, and that's kind of what the reentry specialists can do. But the thing is that they have to be aware of it. And a lot of times they're, Lindsay, who is our current, hang on just a second. Thank you. Lindsay is our current reentry specialist, and she will kind of keep track of things. The deputies tell her things. She works with our classification folks and they find out information, but there's really no solid structure. And part of it is that sometimes there are things that the defense attorney may know that they're not comfortable sharing with us because we're a member of sort of the other side. But I don't have an easy solution, and that's part of the problem. So that's kind of why I'm bringing it to y'all.
Well, the reason I'm saying that is because I know that people in restorative justice programs have performed tasks similar to what we're talking about, that they're sort of a middleman or an explainer or a guide or whatever you want to call it, but we've been calling them navigators, people who facilitate the process and support people who don't really probably understand the system or what their decisions, the consequences of their decisions or not making decisions even.
Maya?
Yeah, Arlene, I mean, I really do see that as the defense attorney's role and our team's role. We have asked for additional support with additional behavioral health specialists. We have 2. We did not get any additional behavioral health specialists in our budget request for this next biennium. We are meeting regularly, like our office is meeting regularly with the lead team, with the health, and I'm sorry, is it human? I don't know the new name for the health department. It doesn't like flow off my tongue yet, but we're meeting with the health department, and we meet regularly also with the Lifeline staff in the jail, the reentry and mental health, and try to coordinate with them. There are limitations. All these folks that are pre-trial, I mean, we're not going to share case strategy with people that are outside of our office. And so much of the work we're doing is creating multiple pathways for someone because they may not yet know if they want to go to trial or whether they want to negotiate an outcome or whether there's some mental health defense or investigation that's still required. And we're pursuing like 8 different avenues for one client where ultimately they're going to choose the path. It's their case, but we need to present to them and counsel them about all of their options. But I'm not going to tell the jail reentry specialist about what we're doing for my client. I'm not going to tell the health department employee about that. I'm not going to tell anyone that works in the jail. So when we don't have people under our umbrella that have the attorney-client privilege, there is a problem. There's a lack of resources there, I believe. And we want to work with lead caseworkers, and we are trying to navigate that. But with folks pre-trial, it's really hard because of the need for confidences.
Thank you. I think I see Kristen, Perry, and Wendy.
So I sat on the SAC, and I'm here today in Deborah Hawley's stead. But I remember hearing about a program for the public defender's office, and I forget what it was called. These like justice workers, but were almost like what Arlene was talking about. And I remember just feeling so encouraged about it because that's where there's this broken link. And it's what Maya was just talking about, because this is serious business. When a person's charged with a crime, they have a lot of rights that need to be protected. and they are being protected. And then in doing so, then these other needs are being neglected, because like Maya said, there's nobody under this umbrella where these superseding rights are. These rights are what the whole system's about. So it is really, I think, so important for any funders to begin to realize that if the public defenders are given some of these resources that are needed to make this connection with the system, it will run more smoothly. So that was a little awkward the way I said it, but it's so important. You know, it's the whole confidentiality issue has sort of taken the back seat here with our good intentions, and it needs to be acknowledged. So, all right.
Thank you, Kristen. Perry?
Yeah, you know, in the descriptions and the challenges that a thought, came up for me that maybe it's possible to identify those individuals that, I'm not sure exactly how to put this together, but for example, have a number of days in jail and they have a court appearance, on this date, and have a list of those individuals. And I'm thinking about it from the jail behavioral health and reentry team, possibly being able to do a screening with that individual of what are the needs that are there if there hasn't been communication at that point. Just in case, you see where I'm kind of going, that it's like, well, okay, we don't know that individual. And as Maya was saying, a lot of decisions can be made, but it's possible to do it, I suspect, at least a screening process in terms of that individual's needs, set that contact and communication up. And in the event that the individual is released, then there's a plan in place, or at least a partial plan in place. And I'm not suggesting if this addresses the issue as much as, is there something that we can do right now? So I'm talking short game. And then obviously other discussions are, a longer term approach, but it was just a thought that I had about that possibility.
Thank you, Wendy and Caleb.
Just real quick, I'm not disagreeing with anything that Maya or Kristen had said. I'm real clear on there needs to be that level of confidentiality, because if the client doesn't trust their attorney, they're not going to cooperate with them. What I'm looking at is, even if maybe we could look at developing, the court calendar comes out, especially on Thursdays, which is criminal calendar, comes out the afternoon before. And that gives us a little bit of a scramble. But if the reentry specialist, or whether it was the behavioral health specialist over at the PD's office, talks to the reentry specialist to see, we've got 24 hours, what can we together come up with is a resolution for this, because it looks like they're going to go for a guilty plea and sentencing tomorrow. That things can happen at the last minute, but and there needs to be those boundaries, but doesn't mean that people can't talk to each other as long as it's not issues of confidentiality. I think that sometimes different parts of the system kind of step behind that, and we've been guilty about it on my part of the world too, kind of step behind that when you're going, this is an individual, either we can release them to the community with no support at all, or knowing that this is going to happen, even if it doesn't happen this week and it doesn't happen until the week after because of whatever, we can start looking and see what resources are available, places that then maybe they could go. Part of the issue is that we all work with a bureaucracy, which tends to be clunky and difficult to get to move. Having a navigator position, which is what Arlene was talking about, the behavioral health specialists and the reentry specialists kind of function in that capacity. We're going to be getting a specialized navigator through our nursing contractor That's going to be primarily for dealing with folks who have physical medical issues and are going to need increased support when they can get out. Because they get lost in the shuffle right now. But what I'm looking at is that we've got people who are staying in jail for a very long time and ultimately going to court and being sentenced to sentences which would have gotten them out months, sometimes years earlier. And I realize it's because the cases are complicated. There's oftentimes a mental health issue in it. But as the chief of the jail, I'm also looking at that those people are not getting moved through our process. So they either go to the community or go to DOC or get transferred to another facility, which means I've got a roadblock in getting things done for new offenders that are coming through. So yes, I have a vested interest in part of this. But the other thing is I've seen too many times where pretty clear communication between prosecutor and the defense and the jail have been able to work out what seemed to be an insurmountable issue because somebody had a piece of information that the other people needed. And once that was shared, not violating confidentiality, we were able to get things fixed. So that's really kind of a woo-woo kind of looking at things, but that communication can help a lot in trying to get some of this stuff resolved. So I'm going to hush up now.
Caleb, would you mind if I interjected just to respond to Wendy's idea? Thank you, Wendy. There's, as you stated, there was no reentry specialist for quite some time. We now have one. We've met with her a couple times. She's great. When those positions are adequately staffed and we're meeting regularly with them, I firmly believe that we can come up with some better modes of communication. I mean, people get noted for a plea typically with 5 days notice to the state. So it's not, I mean, sometimes things get short set, but that's sort of the exception to the rule. The rule is generally you got to provide 5 days notice of that. So, I think there could be a mechanism where when something's noted for a plea, that there is a connection made between reentry specialist and defender to say this person's going to be getting out. You've got 5 days to, like that, I think those things can exist, but we just haven't had anyone there to work with for a very, very long time. So, when that is really happening, I think, we want to meet and talk about ways we can do it better for sure.
Thank you, Maya. Caleb, and then Perry.
Thank you. So a couple things after I'm listening, I want to make sure that it's clear that this is and I know I said this before, but this is a very complicated system with a lot of different moving parts. And so I think that we can tend to think of these in terms of like, well, who's at fault, right? So I want to make sure that none of the language that we're talking about here is it's the defender's office or the public or the prosecutor's office, what have you. And I know that we're all aware of that. I just pointed out that this is a complicated issue, and there are lots of little things that happen all on the process that have ultimate changes in the outcome. So the crux of the matter where we see it from the corrections is it's about timing of information. So we know that if somebody bails out, we have a handful of minutes essentially from when they post bail to the time that they're released. And so if somebody's bailing out on a charge, it's difficult to get reentry involved in that kind of a transition. So if somebody needs those services, but we have a mere moments in time to have those things in place, it's a real challenge. When you are trying to come up with resources in advance, like Perry suggested, it can be a challenge. Like, let's say, for example, we're looking for a housing solution. Well, housing solutions, as you know, they don't just wait around for people to fill. So even if I came up with a housing solution today, it may not be there tomorrow. And so we find some of these challenges in the system and the way that it's made up. It's all about timing. And so that's the biggest problem that we're facing in this whole issue is timing. It's not about, and I understand that there are underlying issues with the timeliness of resolution of cases potentially, but as Maya points out earlier, that's all part of strategy that goes on between the client and their attorney. And that's not necessarily the issue. It's a matter of, do we have enough time for reentry to be effective if we have a few hours? And so if we can add additional time to that process any way possible, that's what I think Chief and I are advocating for.
Perry?
Yeah, to to capitalize some on what Caleb was saying, I think that at least in my thought process, one of the things that I wanted to do was confirm, as Wendy had said, that council did approve additional funding to expand the Lifeline Connections contract, an additional MHP mental health professional, and 2 additional reentry staff. So in addition to, we have some community justice and treatment account dollars for additional SUD assessments to be occurring in the jail and actually in the community for individuals that were releasing from the jail. But I would, again, that idea of well, maybe we can get some of this information, and my thought process was for those individuals, do a very streamlined screening process for those individuals that requires less time. Of course, it's going to be less sophisticated, but a couple of things I think end up happening. Number one, obviously the reentry specialist gets an opportunity to communicate with the person about what those needs are, and that information can be retained. If the individual doesn't happen to release through the court process or what have you. So it can be used, obviously, in the future. And this streamlined process, taking into account that we have a very limited period of time, and so would have to do a much more rapid reentry contact kind of communication component. That I don't know for a fact that hasn't been developed, but I suspect that out of almost necessity being the mother of invention, that there may be some development of that, at this point, and so formalizing that, to a certain extent. And again, I realize that I'm talking short game as opposed to long game. Not that I'm not interested in long game.
Thank you, everybody. I don't see any other hands, so I'm going to give it my 2 cents because I like to do that. I kind of feel like as a small municipal court out here, I am the side order. I am the sour cream that you want to order, or the tartar sauce you want for your fries at a restaurant. And I love food, and it's lunchtime, so that's where you're getting my analogy. I like the Cheesecake Factory in Seattle. And there's lots of different parts to that restaurant. There's people that bring food in, and I originally thought it was just cheesecake, but what do you know, when you go there, there's this huge menu and there's all these different items that you have to choose from and select. And then you've got the wait staff, and you've got the bar people, and you've got the chefs, and you've got the people bringing things in, and you've got the delivery, but it all works together. People are mostly satisfied when they walk out of there. The jail is not necessarily that satisfied, smooth running machine because of so many issues. And I don't know that we can solve all of them and that we're going to be as smooth as the Cheesecake Factory. But I know Judge Lewis called me last week, Thursday, and said, hey, Raylene, we've got a defendant in common in custody. And I see that you have a warrant for him as well, and I'm going to have him here. I'm sure he'll probably be there till Tuesday, but if he's not, I didn't know if you wanted to try to get a hearing in there so your warrant's resolved too. That was a common courtesy. He didn't have to call Blaine and let me know that. I then called the jail and said, hey, do you know if this guy's going to be out anytime sooner? Do I need to get prosecutor and defense? And do we need to do a special set so that we can get this case taken care of? Yeah, it's only one little case. It's just the side order, but it's that little case. Then on another note, we have a defendant that's got felony charges that's represented by private counsel that I went to in custody hearings last Tuesday morning, and he didn't want to come out of his cell for his hearing. And so we didn't hear our case. We've got bail set on him, so the city is, you know, paying daily fees for him to be there. It's a combination because he's got felony charges there too. But another clerk went down to see him today with another judge, another hearing, and he still didn't want to come out of his cell. So like I said, there's a lot of moving parts. There's a lot of different issues. We've got mental health issues. We're going to be discussing that at our joint behavioral health meeting with Thomas Kinlan from the state on some of those issues as we work together trying to bring this together cohesively. We can't just forget about the tartar sauce. When we talk about reentry, when we talk about behavioral health, sometimes we're talking about reentry of offenders that don't have all of those components, but have one little component. And then when we don't worry about those little components, they get bigger. And then they have all the components. And then they're in 3 different courts and they've got felonies pending. So it's just, I think as we continue to go, we all recognize that there's separate parts and there's confidentiality, and I don't want to step on that. But when we have a defendant that's sitting on felony charges that needs a competency evaluation, 9 times out of 10, we're waiting for one too in the municipal court. And so I don't know if that reentry specialist is able to say, hey, this person has cases in 3 other courts. What is the status of those cases? Can that individual call and say, hey, Maya, did you know that we have a defendant that has court in these 3 cases? Do you guys have a competency eval going? Do we need to have 3 separate ones? Is that a requirement? I don't know all the laws on that, but somebody else might. And so I think that's something that we want to look at and maybe meet with some of these reentry specialists as a group on what can they do, what can't they do, what are they expected. I mean, yes, they work for one person, but having the group as a whole understand that as a process might be beneficial in the future. And if I'm wrong, don't be afraid to tell me. I got big shoulders. Anyways, thank you all for participating and giving us that information. Is there any more comments or questions on this subject? I'm sure it's going to be coming back to us. I see Stephen's hand up. Thank you.
Raylene, thank you. The agenda lists this item as the Reentry Coordinating Council reporting. And your point about can't we get all these people together talking about this? I thought that's what we had going on. So that tells me I'm confused, or somebody's not talking to somebody. And I wonder if somebody could explain the coordination that is going on and what you see as what add-ons could be put in place there.
I guess I'm looking at when we talk about, we have one person that's a reentry specialist that isn't here at the table, probably because she's running around like a chicken with her head cut off. We've got 2 other positions that are going to be filled. Can we get them to join us in the future? Is that something that's possible? To say, this is what we need, this is what we can do. We've got people from all different areas that might be able to weigh in. And I see Maya's hand up.
I mean, I just would say they've been really willing to meet with us and have come over to our office to meet with our different attorney groups. And it's useful for, they're really busy right now. And I felt bad taking an hour from them to come, 2 hours actually, because they came to 2 meetings. And so I think maybe when they're better staffed, we could ask that from them. I mean, I think they're working really hard to just communicate with the immediate people they need to be working with right now.
I respect that. Thank you. Caleb?
Yeah, I would just say, on their behalf, Lindsay is specifically focusing on individual interactions and client priority at this point. So she isn't going to a ton of meetings at this point.
Yes. Wendy?
30-second question. Maya, do you think it would be possible that when you guys send the notice to the state that, you know, for guilty plea and sentencing, that a copy could get kicked over to the jail? Because that would give us a heads up that it was, that at least you guys were getting close.
Right. I think I could maybe get people to do that, but I think I need to talk to and communicate with the reentry specialists
Oh,
to
yeah.
determine what the utility of that would be. And yeah, so yeah.
Thank you.
Thank you, Perry.
You know, Renee, in response to your thought process there, which makes, you know, good sense to me, a couple of things. I recently took over administering the contract with Lifeline Connections when my colleague Jackie Mitchell had changed positions to do something else. And one of the things that we've been actually focusing on, we have regular meetings, obviously, with Lifeline Connections relative to the jail behavioral health services. And I think certainly having the supervisor, the managers, you know, come in, I think that talking directly to the reentry specialists as opposed to the administrators that are designing, you know, those services and programs is probably not at the right level. Not that they can't come in and talk about their experiences. I think that we're pretty well describing, you know, that they're, you know, running as fast as they can and not able to obviously fulfill that. But honestly, you know, one of the things that I've experienced in the very brief period of time that I've been administering the contract and attending the meetings is coming up with some ideas. For example, one of the things that's happening for the reentry specialists is referrals and or kites that are coming from individuals that are incarcerated all come to the reentry person, if it even looks like it's sort of in that, you know, arena. And so they're going through a whole lot of paperwork that actually doesn't apply to them. And so we came up with some ideas about streamlining that process. And also, as Caleb had actually mentioned, really kind of just did a time study of, okay, what is the one reentry specialist at the time? What is that person doing? And actually reduce the number of meetings that that person was going to, not in the attempt to, you know, reduce the knowledge that they had, but really to bring more time face to face with the individuals that reentry services are needing to be provided. So that would be my suggestion is, by all means, you know, let's bring in and have, you know, discussions with the administration and the people that are supervising, you know, at that point in time, and certainly myself, you know, in terms of the ideas. I think this discussion has been really helpful, but that would be my suggestion.
Thank you, Perry. Arlene?
Well, from listening to what you all are saying, it does seem like the quote unquote navigator tasks are going to the reentry specialists. And that if we want them to be able to do their task, that it would be wise to watch their caseload. And that would suggest possibly more staff than what we're talking about. Because if you want someone to be able to do their job, you have to watch their caseload, that they're not overloaded, especially if they have all those many side dishes to look after. So that's something to think about in the future. I love this discussion. It's wonderful.
Thank you. This has been an excellent discussion. I think it will probably carry on in the future. But I do see that I still have Deborah Garrett and Judge Freeman on here, and we're running out of time. I wanted to give them a little bit of time to give us an update on the pretrial processes work group. That's unless they've left us.
I'm
already.
sorry, it took me a minute to unmute, and I'm going to try to put my camera on too, so you know it's really me. There we are. Hi, everybody. Nice to see you all. And I think Judge Freeman and I can sort of tandem this with a little help from Stephen as well. This is just a report on the status of the work of our work group. And you'll recall that the work group is a group of mostly participants within various aspects of the pretrial system to establish pretrial services and then administer that. And well, that's where we are. I mean, that's what we're supposed to do. Where we are is an interesting point because COVID changed a lot about who gets incarcerated pre-trial. And between COVID rules from the Supreme Court that very much expanded the mandate to the courts to release people pre-trial, if at all possible, consistent with community safety. There's also the fact that here in Whatcom County, we have a jail that is beyond capacity in terms of its bookings. So that has changed. Our work group and our pretrial services department was originally focused on those cases of defendants that I would call marginal in their pretrial status, in that they are people who are not likely to be able to comply with all of the appearance requirements, coming into court for what at the time was a seemingly endless series of pretrial hearings with huge penalties for missing any of them. People who aren't super functional, and even some who are super functional, miss court dates sometimes, especially if they have one every 60 days and their case is pending for 3 years. So that was one of the goals of our pretrial services. Since then, the rules have changed quite a bit. So these in-person appearances in court aren't required nearly as much. So people aren't getting rearrested and charged with bail jumping felonies for not appearing for pretrial hearings, which is a huge change. Another huge change is that, frankly, people who are accused of crimes that don't involve serious issues of community safety are being released at a rate that's unprecedented in my knowledge, my experience certainly, but also my knowledge of the court system, simply because there's not room for marginal people. The people who are in the jail are people who really do pose a risk to community safety or to themselves or to specific individuals in the community. So that requires a revamping of pretrial services. Certainly, we find that we've been working on statistics with our statistician, Dr. Andrew Peterson, and certainly we're finding in the jail data and our own data that a lot of people who either are not booked pretrial or are initially booked but then released pretrial are not succeeding in getting to trial. And we have defined success as avoiding arrest for a new crime and avoiding a failure to appear for a required hearing. What we're finding is that although the failure to appear piece is heavily diminished because the appearance requirements aren't nearly as many for defendants, we're finding that, I guess not surprisingly, the longer a person is in pretrial status, in other words, the longer the time between when they're accused of a crime and when their case is either tried or a plea is entered or the case is dismissed, the longer that period of time, the more likely the person is to fail at pretrial services. And what we're really concerned about is not so much the failures what we're concerned about is not the marginal failures where a person is, I don't know, accused of shoplifting or doesn't appear for a hearing, but there's a mix up and they're not lost to the system. What we're concerned about is more serious failures. And though at the top of the list there would be the person goes out and participates in activities that cause them to be accused of a new and violent or otherwise serious crime. That's the big failure in pretrial services. And that's what we're trying to avoid. So we have some goals here, and they require some changes in our approach, because the pretrial services that were designed to help people who don't have strong executive skills make their court dates, that's changed. And now what we're trying to do is sort out those people who can be helped to not be a serious risk to the community so that they are releasable pre-trial. And we also want to see, along with the judges, we want to see cases getting to trial sooner. Because, you know, if you wait long enough, almost every defendant is going to be messing up somewhere on their pretrial status if their pretrial goes on indefinitely. So we're looking to work with the court on that. And I know the court has taken some significant steps in shortening the pretrial time. And that's a really good thing. We're also looking to revamp pretrial services so that we can look at offering more, what would you say, human services to defendants, working with the LEAD program and some of the other mental health and other professionals. As we know, as an instrument of the court, the pretrial services unit is not legally permitted to require any kind of service. I mean, a defendant is presumed innocent until convicted. And we have no more right to require alcohol treatment for a defendant on pretrial services than we have to require that for any of us. You know, the fact that a person's charged with a crime doesn't permit the court in the guise of pretrial services to intervene. But there's a lot that can be done with voluntary services. And I think we're seeing that in the reception that other programs are getting from this community. So going forward, we're looking to revamp pretrial services in terms of the community that we're serving now. The fact that mental health issues dominate in a way that they didn't 5 years ago when we were setting up pretrial services. And the head of pretrial services, we have 2 pretrial service officers. One of them, John Kraus, has left the county, and our work group sees this as a good time to revamp the program and continue to, police is the wrong word, but continue to monitor the success of defendants on pretrial services and bring failures to the attention of the court, but also to give services to people on a voluntary basis that are a bit more user-friendly and aim to help people with the problems that have caused them to come into the criminal system, in addition to monitoring to make sure that they stay out of trouble and show up for their court hearings. I think I've hit the high points, but I'll ask Dave Freeman and Stephen Gockley to please add whatever you'd like. Hi, Judge Freeman.
Hi, Deborah. I don't really have much to add. This is something that, given John leaving the program recently, has certainly been a point of interest for the judges and what direction we go in this program going forward. And so that's actually, I missed our last meeting in part because I was part of a work group with the judges on this as well that day. And so it is something that we're looking at, both monitoring and accountability aspects of it, but also something that I think Maya has brought up in a number of our meetings. And that's, you know, pretrial also being a point of contact for other services that might be available.
Absolutely. Stephen, anything you'd like to add?
I thought that was an excellent summary, Judge Garrett, and thank you very much. The one thing I would say is the other part of the pretrial processes work group's charge was implementing the public safety assessment, the pretrial risk assessment tool. The Superior Court judicial officers have been doing that, but the reason so much attention has gone on pretrial services is that if you don't have an effective monitoring regimen going on, the judicial officers are increasingly wary of following the recommendations that flow out of that risk assessment. So that's sort of put on the back burner. We have Dr. Peterson continuing to track data on that, but we need to get a better and a more currently appropriate handle on pretrial services what we're shooting for there, how we're adjusting to the different population of those released pretrial for those services before we can really charge ahead with the risk assessment and expect the full effectiveness that we hoped for when the judicial officers adopted that. So that's still on our radar screen, but it's a little bit secondary as I'm tracking our conversations in the work group, and for good reason. The priority has to be on refocusing pretrial services.
Yeah, I think that's where we are. We continue to meet. Our next meeting is in March because we want to facilitate this discussion moving forward. And that's where we are. So expect big things, but not yet.
Thank you so much, Judge Garrett and Judge Freeman and Stephen Gockley. Is there any other comments or questions on this matter? We really do appreciate you guys taking the time out to work on this committee and update us. I think we're going to have to move quickly through. Is there any other business? No, I appreciate everybody staying a little bit late. Is there any public comment? Jill, can you assist?
Yes, we have a couple of attendees at the meeting today. If you would like to speak to the committee, please virtually raise your hand now, or if you're on the phone, you can press *9. And no hands are raised.
Once again, thank you all for staying a little bit late. I'm going to adjourn this meeting. It's 12:42, and I look forward to seeing you all at the next joint behavioral health meeting in March. Have a great day.